If they have protections, what are the main protections we're talking about? Now, remember, I said there's kind of an overarching umbrella of protections. We're going to focus on the lending specific ones, or the ones that most financial institutions need to worry about. And the big one is the 6% interest rate cap. Now, it's not just a cap on interest rate for the period. You actually have to forgive interest that's been paid over time. So typically, to receive this benefit, the lender has to be generally has to be notified, and most service members, they're instructed to notify their lender in writing and to include a copy of their orders so it's very clear, or have a letter from their commanding officer that really kind of lays out their period of service. But there's several ways that you can make sure that you're complying with this. But high level, what exactly does this mean? The 6% interest rate. Well, first off, it requires a rate reduction. So you have to reduce the interest rate. If anything's over 6%, you have to reduce it down to that 6%. And it's and also you're going to be recalculating the amortization schedule. Okay, so you have to forgive any interest that was paid that's over that 6% threshold during that period of service. Okay, so that sometimes can get a little fuzzy. Also, you're going to refund any of those excess payments that are made. So in that time that it takes them to get a message out to you, maybe they're a little late on letting you know, you have to go through and figure out what it would have been if they were capped at that 6%. And you should also provide a refund if they paid more than they should have under these protections. You have to provide a refund, and that's don't play games here, because I've seen a lot of questions on, well, what if we just credit it to the balance or things along those lines. I've seen banks criticized for using those funds anything short of a refund. So just be aware that they want those funds to be available for the service member to actually use. Also, because of the definition, when they talk about that 6% cap, it includes service charges, any renewal charges, fees, and other charges. So it may not be enough just to look at that 6% interest. You may have to go through and either decrease or eliminate certain fees and charges and annual fees along those lines to make sure that you keep it below that threshold. Okay, so just going through and recalculating, reamortizing might not be enough if you have some of those fees that are involved. Go ahead and let's take a look at number 2. So we're at the bottom of page 4. Keep in mind that this is all debts. All debts as of the date they are called into military service, through that entire period. So therefore, all debts or any portion that is during that time period, if they take any debts while they're on active duty, then we're not talking SCRA. We'll talk about Military Lending Act there. So we're talking about debts that are in existence. The individual goes into active service. That's the period we're talking about. If they are already in active service and they're incurring new debts, or they're taking out a new loan, that's going to be a different regulation we're talking about. And really, I want to make sure we're clear on that under number 2 there. And if you want to take a look, it's all debts or any portion thereof incurred during that period of their active duty military service are not covered here. Okay, so that's a common area of confusion I've found when I've gone out and talked to folks. So what are some of the triggers? I jumped ahead too far there. What are some of the triggers? Let's flip to the next page, top number 3. When do you have to act? Well, first, it's when you receive written notice with a copy of their orders, something that lets you know that, okay, yes, they are in active duty, and you can prove it. But look at the note at the bottom there. You shouldn't be conditioning all of these benefits on any specific forms or documents. In short, what they're saying is, don't play games with this. Okay, if you've received the written notice, you can have a reasonable process where you go through and you verify and you make sure that the bank isn't being subject to some kind of fraud being perpetrated on them. But at the same time, don't make them jump through unnecessary hoops to get these protections. These protections are supposed to be relatively easy for them to get. So making them jump through unnecessary hoops, or denying coverage because, well, you didn't fill out the appropriate form form and sit it through this appropriate channel. Really, it's designed to be relatively easy. You need that minimum, that kind of minimum notice to get started. There's also a safe harbor that's built into the rule that you can actually go to the Defense Manpower Data Center, and there's a website in there that you can check out, but you can go and verify it yourself. Maybe you want to rely on your own process where you go through and you receive that written notice, and then you go through whatever documentation process that you want to kind of minimally establish that they do have that protected status, or you can go through and do this independent verification. Practically speaking, I know most service members are instructed to provide that written notice and to provide a copy of their orders as well. Their resources kind of tells them to do that, but it doesn't always work out that way, especially if you have a claim from a dependent or something along those lines. So you would either have to have a written process or a process that you go through to verify it, or you can do that safe harbor that's on the page there. How long, how long are they protected? And so if they seek this protection and they want this interest rate cap, how long is that in place for? Well, it's their period of military service, and that's why we spent some time talking about the definition there, because that's the period that we're going to look at, and we're going to reduce any rates. We may have to cut fees, whatever the case may be. That's the period that we're going to look at and we're going to modify. Keep in mind, if it's a mortgage-related debt has a special rule. So look at letter B under number 4 there. It actually extends out for 1 year after the end of their military service. So there's an additional protection if we're talking about mortgage-related debt. Also, look at number 5 there. Important to note that there's an exception that's out there. And so if a court, okay, so this I don't want to lose everybody with this exception. It does exist, but look at what it says there in italics. If a court finds that the service member's ability to pay the interest rate that was already agreed upon, if their ability to pay that was not materially affected, so in other words, they went into active service, but really there was no reason why they had limitations in their ability to pay that higher rate. You could have an exception there if you go through, but keep in mind, this is a legal relief, so you'd have to go to court to get it. I wouldn't incorporate this exception into your compliance process and procedure. It might just confuse things, or it might cause violations unnecessarily. So know this exception's out there, but you might want to touch base with whatever legal counsel you have engaged before you go through and try to exercise this exception. It's good to know that it's there. I would just hate for that exception to cause more problems, especially in the limited circumstances it's ever applied. So look at letter B. There is some additional restrictions. So we've got the 6% interest rate cap that's out there. There's also a prohibition out there, if you look at letter B, from lenders rescinding or terminating a contract. Now, keep in mind, so in other words, you are not allowed to just go through and rescind a contract simply because they go into active status. However, there is a little caveat here, and look at that next line that's in your materials. This protection, or this prohibition against rescinding or terminating this contract for the purchase of real property, so like a car or something along those lines. You can't rescind it just because they went into service and they're exercising their protections. However, there's an exception out there. That protection only applies if they have made a deposit or they've made at least one installment. So in other words, if they haven't made any payments yet, they don't get this protection. Okay, so you could technically terminate an agreement if you never received any payments. But as soon as they start paying, or they make that payment on any kind of installment agreement, then they receive that protection. Letter C, another big one. There's a restriction against any kind of foreclosure. So if you're going to foreclose on the property, you want to make sure that your attorney knows their status and understand that this protection's in place. Also, though, this protection, and sometimes it gets confusing, it's also about seizure of their personal property. So it's not just about foreclosing on real estate. I don't want to get confused there too, because I've actually talked to people who, in their head, they thought, no, that foreclosure, that we're not foreclosing, we're just taking back the car. Keep in mind, you can't be, security interests can't be sold or foreclosed or seized. Without a court order. So you can't just exercise your right of self-help here. You actually have to go through the court system, okay? And then the court is also authorized to stay a proceeding, if they find out that there is somebody who should be protected under this. So it's very difficult to go through if they, and go through that foreclosure or seizure process, and you'll have to go through a court in order to do that. Look at letter D. Evictions from bank-owned property. There's this general rule out there that you can't evict them during that period of military service except by court order. So you can't go through any standard eviction process that might be out there. And then also you have to provide notice. Before you go through any kind of eviction process, you have to provide notice, and that notice is the SCRA notice. If you're looking at letter D, that's what it's talking about. You have to explain their mortgage and foreclosure rights. You have to provide them with a toll-free number, and there's a standard format that we typically see. If you want to flip ahead and look at page 9, that's the notice that we're talking about. It's probably something that you recognize because it's a very standard notice that goes out. It goes to service members and their dependents. Okay, so that's what that requirement is. And the problem with so we're required to send this notice to service members and their dependents prior to any foreclosure or eviction. The question becomes, who's a dependent? Remember when we went through those definitions, a dependent is a very fuzzy term. It might be moving, there are timeframes attached to it, and there's no way that you can know for sure whether or not you have a dependent on your hands. So that's why this particular disclosure goes out to everybody. It goes out to, anytime you have a delinquency, this one goes out to all of your borrowers, simply because we don't know whether or not they may or may not be a dependent. There's also some limitations. If you look on letter E, life insurance, there's some limitations there. A lot of times typically banks aren't involved in that. But look at letter F. We're going on to page 7 here. The adverse actions. This is good to be aware of. The fact that a service member applies for protections or any kind of stay or postponement or suspension of their obligation, the fact that they exercise their rights under this reg can't be on its own the basis for determining that they were unable to pay, or that you can't deny a request for credit specifically just because they've requested protections under this at one point or another. Adverse credit reporting, just because they exercise their rights doesn't mean anything bad's happened. It can't be on its own a determination that they couldn't pay. And if you look, look at number 1 on the page there. What they're getting at is don't exercise your contract rights of default just because they came in and they're trying to exercise their rights. Exercising the rights under this wouldn't be an event of default. You need to wait for an actual default under these kind of modified terms before you would be able to determine that they were unable to pay. Like number 2, that denial, practically speaking, just because I've exercised my rights under this particular reg can't in and of itself be a reason to deny future requests for credit, even if it's a modification. So if I come through and I request a modification on existing debt, keep in mind you shouldn't be denying it just because I've exercised my rights under this particular reg. Now there may be other things in addition to the fact that I've exercised my right. It doesn't necessarily mean that you have to grant every single credit request that I make going forward. It's just you can't deny it only because of my exercising of these rights.